Hello friends. Imagine you are returning to the United States after visiting your family overseas. Your passport is valid, your visa has not expired. You have all the documents you were told to carry. You step off the plane feeling confident that everything is in order. But as you approach the immigration checkpoint, you notice people around you talking about a major Supreme Court decision that could change how immigration policies are enforced. Suddenly, a question crosses your mind. Could this affect me even if I have done everything the right way? That feeling of uncertainty is exactly what millions of immigrants, international students, temporary workers, tourists and families are experiencing today. But here is what most people still do not realize. The latest Supreme Court ruling is not just another legal headline. Even though the court did not end birthright citizenship, many legal experts believe its decision could still make it easier for large parts of President Donald Trump's immigration agenda to move forward while legal challenges continue, and that is why this case matters far beyond the courtroom. To understand what happened, we first need to separate two issues that many headlines have mixed together. The first issue is birthright citizenship. For more than a century, the general understanding of the 14th Amendment has been that almost anyone born on United States soil automatically becomes a United States citizen, with only a few limited exceptions. That constitutional question has not been finally decided by the Supreme Court in this case. The second issue is something that sounds much more technical, but may end up affecting immigration policy much sooner. It is called a nationwide injunction. Before this ruling, a single federal judge could sometimes temporarily block a presidential policy across the entire country, while the courts decided whether that policy was legal. That meant an executive order could be put on hold nationwide before the legal fight was even finished. Now, the Supreme Court has signaled that this kind of nationwide block should be used much more carefully. In many situations, lower courts may only be able to protect the people or organizations directly involved in a lawsuit instead of stopping a policy everywhere at once. At first, that may sound like a procedural change that only lawyers need to understand. It is not. For millions of people affected by immigration policy, this change could have real-world consequences. Think about it this way. If a future immigration policy is challenged in court, that policy might continue operating in many parts of the country while lawsuits move through the legal system. Instead of one nationwide pause, there could be different legal situations happening at the same time. This is where many people make a mistake. Some assume that once a lawsuit is filed, a new immigration policy automatically stops across the entire United States. That is no longer something anyone should assume. Depending on the circumstances, certain policies could remain in effect while courts continue reviewing them. That distinction may sound small, but it could shape how future immigration decisions are carried out. Supporters of the court's approach argue that a single judge should not have the power to stop a federal policy affecting the entire nation before higher courts have fully reviewed the case. They believe nationwide injunctions have been used too broadly and that limiting them allows elected administrations to carry out their policies unless those policies are ultimately found to be unlawful. Critics see it differently. They argue that nationwide injunctions have often prevented potentially unlawful government actions from affecting millions of people, while courts considered the facts. Without those broader court orders, they worry that individuals could face different legal protections depending on where they live or whether they are personally involved in a lawsuit. Regardless of which view someone supports, one thing is becoming increasingly clear. The Supreme Court is changing not only what immigration cases look like, but also how those cases move through the judicial system. And that is where President Trump's immigration agenda enters the conversation. Over the years, many of the administration's immigration policies faced immediate legal challenges. Several were temporarily blocked by lower federal courts before they could take full effect. Those court orders often applied nationwide, meaning the policies were paused across the country while litigation continued. The Supreme Court's latest decision does not automatically approve every future executive order. It does not mean every immigration policy will survive legal review, but by making nationwide injunctions harder to obtain in many situations, the court has created a legal environment where future administrations may have a greater opportunity to enforce certain policies before the courts reach a final decision. That is why many constitutional scholars say this ruling could strengthen executive authority not only for this administration but for future presidents as well. What happens next is the part that surprises many people. The biggest impact may not come from one single immigration policy. Instead, it may come from the speed at which future policies can take effect while legal challenges are still unfolding. For immigrants and their families, timing suddenly matters more than ever. If you have a visa application pending, if you are waiting for a decision from USCIS, if your employer is sponsoring an H-1B petition, if you are studying in the United States on an F-1 visa, or if your family is working through the immigration process, policy changes that occur during your case could become increasingly important. That does not mean your case is suddenly at risk. It means staying informed has become one of the most valuable tools you have. And before you assume this only affects people applying for immigration benefits, there is another important part of this story that almost every headline leaves out. It involves travelers, airport inspections, and the way immigration officers may apply changing policies while legal battles continue. Understanding that connection could help you avoid mistakes that many people never see coming. Most travelers never think about immigration policy until the day it affects them. You book your flight, check your passport, confirm that your visa is still valid, and assume everything else will work the way it did the last time you entered the United States. In many cases, it does. But immigration law is not static. Policies can change while your application is pending, while you are outside the country, or even while you are in the air on your way back. That is why this Supreme Court decision has attracted so much attention. It is not because every immigration rule suddenly changed overnight. It is because the legal process for challenging those rules may be changing, and that could affect how quickly new policies are implemented. Imagine an international student studying in the United States on an F-1 visa. She has completed every requirement, maintained full-time enrollment, and is preparing for optional practical training. While her paperwork is being processed, a new executive immigration policy takes effect. A lawsuit is immediately filed, but instead of stopping the policy across the entire country, the legal challenge protects only the parties directly involved in that case. Suddenly, thousands of students begin asking the same question. Which rules apply to me? That uncertainty is exactly what immigration attorneys expect many people to face whenever significant policy changes are announced. The same concern applies to temporary workers. Whether you are in the United States on an H-1B visa, an L-1 visa, a J-1 exchange visitor program, or another employment-based category, your long-term plans often depend on predictable government procedures. Employers make hiring decisions months in advance. Families sign leases, buy homes, enroll children in school, and build careers around the expectation that immigration rules will remain reasonably stable. When legal uncertainty increases, planning becomes more difficult. This does not mean those visas suddenly become invalid. It means applicants should pay much closer attention to official announcements because policy changes may begin operating before every lawsuit has reached its final conclusion. This is where many people make another mistake. They confuse headlines with immediate legal reality. Within hours of every major immigration decision, social media fills with dramatic claims. All visas are cancelled. Green cards are no longer safe. The borders are completely closed. In reality, immigration law almost never works that way. Most changes move through several stages. An executive order may be announced. Government agencies such as the Department of Homeland Security, USCIS, or the Department of State may issue implementation guidance. Lawsuits may follow. Lower courts may issue temporary rulings. Appeals may continue for months or even years before the Supreme Court reaches a final constitutional decision. That process can be frustrating, but understanding it helps people avoid making expensive decisions based on fear instead of facts. What happens next surprises a lot of people. Even when legal challenges are still underway, officers at ports of entry continue applying the policies and guidance that are legally in effect on the day you arrive. If you are returning to the United States through a major international airport, your inspection is conducted by officers from CBP. Their responsibility is to determine whether you are admissible under the immigration laws and current federal guidance. They may verify your passport, visa, travel history, purpose of your trip, supporting documents, and, when legally authorized, ask additional questions related to your eligibility to enter the country. Those inspection powers are not new. They have existed for many years. What changes from one administration to another are the enforcement priorities, operational guidance, and policy objectives that officers are instructed to follow. That is why experienced immigration lawyers often remind clients that having a valid visa does not automatically guarantee admission into the United States. A visa allows you to travel to a port of entry and request admission. The final inspection still takes place when you arrive. For most lawful travelers, that process is routine. But when immigration policies are changing, preparation becomes even more important. Make sure your travel documents remain valid. Carry supporting paperwork that matches the purpose of your trip. Review any official travel advisories or immigration updates before your departure. If your situation involves a pending application or unusual circumstances, seek qualified legal advice before making international travel plans. These simple steps may prevent unnecessary complications later. Families waiting for immigration benefits should also pay close attention. Across the country, thousands of people are waiting for family-based petitions, employment-based adjustments, naturalization interviews, asylum decisions, and other immigration benefits. Many of these cases take months, and sometimes years, to complete. During that time, government policies can evolve. That does not automatically change the outcome of every application. But it does mean applicants should respond promptly to requests from USCIS, keep their contact information updated, and continue following all legal requirements while their cases remain pending. Another group watching these developments very closely is employers. American businesses rely heavily on skilled international workers in healthcare, engineering, technology, education, and scientific research. When immigration policies become uncertain, companies often face difficult decisions about recruitment, staffing, and long-term investments. The effects extend far beyond immigration offices. They can influence universities, hospitals, research institutions, and businesses throughout the economy. This is why many legal analysts say the Supreme Court's decision reaches beyond one administration or one political debate. It changes the legal framework that future presidents of either political party may use when implementing executive policies. Some experts believe this strengthens the executive branch. Others believe it places greater responsibility on Congress to pass lasting immigration legislation instead of relying on executive actions that can change from one administration to another. Whichever view ultimately proves more persuasive, one fact remains the same. The immigration system continues to evolve. And the people who usually navigate those changes most successfully are not the ones who react first. They are the ones who stay informed, verify official information, and prepare before changes directly affect their cases. Because before we finish, there is one final piece of this story that could matter the most. It explains what this decision means for the future of immigration policy, why more legal battles are almost certain, and what practical steps you can take right now to protect yourself, your family, and your future in an immigration system that may continue changing for years to come. The truth is, this Supreme Court decision is probably not the end of the story. In many ways, it is the beginning of a new chapter in the legal battle over immigration policy in the United States. That is because the court's ruling did not decide every constitutional question surrounding President Donald Trump's immigration agenda. Instead, it changed an important part of the legal process that determines how quickly future policies can take effect while challenges work their way through the courts. For millions of people, that difference matters. If a future administration introduces another major immigration policy, lawsuits are almost certain to follow. But unless a court finds a legal reason to issue broader relief under the applicable rules, some policies may remain in effect for many people while judges continue reviewing the case. That means future immigration debates may unfold very differently from those in the past. Some policies could be implemented more quickly. Others could still be delayed. Some may ultimately be upheld, others may eventually be struck down. That uncertainty is now part of the legal landscape. This is why immigration experts continue repeating one important message. Do not make major life decisions based only on breaking news headlines. Headlines are designed to capture attention. Your immigration future deserves much more than a headline. Instead, pay attention to official announcements from agencies such as USCIS, the Department of Homeland Security, the Department of State, and CBP. If you receive a notice about your own case, read it carefully and respond within the required deadlines. If your situation becomes legally complicated, speak with a qualified immigration attorney who can evaluate the facts specific to your case. Every immigration journey is different. A student on an F1 visa faces different legal questions than an engineer working under an H-1B petition. A family waiting for permanent residence has different concerns than someone applying for naturalization. A tourist visiting on a B1-B2 visa has different responsibilities than an employer sponsoring international workers. That is why comparing your case with someone else's experience can sometimes create unnecessary confusion. Your documents matter. Your immigration history matters. Your filing dates matter. And your compliance with existing immigration laws matters. This is where careful preparation becomes one of your greatest advantages. Keep copies of important immigration documents in a secure place. Monitor official case updates regularly. Inform immigration authorities whenever the law requires you to report changes, such as an address update. If you are planning international travel while an application is pending, make sure you understand how that travel could affect your specific immigration category before leaving the United States. These practical habits cannot eliminate uncertainty, but they can help reduce avoidable mistakes. Another important point often gets overlooked. The Supreme Court did not declare that every future executive immigration policy is automatically lawful. Each policy can still be challenged. Federal courts will continue reviewing executive actions. Constitutional questions can still reach the Supreme Court. Congress still has the authority to pass new immigration legislation. And future presidents may adopt different priorities from previous administrations. In other words, the immigration system remains dynamic. That means today's legal environment could continue evolving over the coming months and years. For some people, that reality creates anxiety. For others, it is a reminder that patience and preparation remain essential parts of every immigration process. One thing is certain: reliable information has never been more valuable. Unfortunately, misinformation often spreads faster than the facts. A single social media post can create unnecessary panic within hours, even when it misrepresents what a court actually decided. That is why taking a few extra minutes to verify information through official government sources can save you weeks or even months of confusion. Remember what this case actually tells us. The Supreme Court did not issue a final ruling ending birthright citizenship. Instead, it limited the use of nationwide injunctions in many circumstances, making it more difficult for lower federal courts to block executive policies across the entire country before those policies receive full judicial review. Many constitutional scholars believe that procedural change could strengthen the ability of future presidents, including President Trump, to implement parts of their immigration agendas while legal challenges continue. Supporters say this restores the proper balance between the executive and judicial branches. Critics argue it could allow disputed policies to affect more people before courts determine whether they are constitutional. Those debates will almost certainly continue, but regardless of politics, the practical advice for immigrants, visa holders, students, workers, tourists, and families remains remarkably consistent. Stay informed, keep your records organized, follow official guidance, meet every filing deadline, do not rely on rumors, and never assume that one dramatic headline automatically changes your legal status overnight. Let us quickly recap the most important points. Birthright citizenship has not been overturned by this ruling. The Supreme Court's decision focused primarily on limiting the use of nationwide injunctions by lower federal courts. That procedural change may allow some executive immigration policies to remain in effect while lawsuits continue. If you have an immigration application pending, are planning to travel internationally, or expect to deal with USCIS or CBP in the near future, staying informed and prepared is more important than ever. The people who usually navigate immigration changes most successfully are not the ones who react with fear. They are the ones who respond with accurate information, careful planning, and patience. As the legal landscape continues to evolve, new court decisions, agency guidance, and legislative proposals are likely to shape the next chapter of American immigration policy. We will continue following those developments carefully so you can understand not only what changed, but also what those changes actually mean for you and your family. Every immigration case is unique, and this video provides general educational information rather than legal advice for any specific situation. If your case involves complex legal questions, consult a qualified immigration attorney before making important decisions. If you found this breakdown helpful, share it with your family, friends, classmates, co-workers, or anyone whose visa, immigration case or travel plans could be affected by these ongoing legal developments. Stay informed, keep checking official government sources for verified updates, and subscribe for clear, balanced, and practical immigration news that helps you make confident decisions in a system that continues to change.